Hello and welcome. My name is Brad Micklin, and in 1 second, I'm going to be starting our webinar, Keep Your Divorce Private, Even as a Public Figure. So as I said, my name is Brad Micklin. In case you haven't worked with me, this is me. I'm a licensed New Jersey attorney to practice in state and federal courts in New Jersey. I am the founder, managing member of the Micklin Law Group. We are a law firm concentrated in men's and fathers' rights in custody, divorce, and family law matters. And we have offices in Nutley, Montclair, and Saddlebrook, New Jersey. I want to thank you for attending. I certainly hope this information helps you. So we'll move along, give you a little background first about myself. Again, for those that might not have worked with me, here are some awards that I've been privileged to receive from clients and colleagues. I put this here not to impress people, but to impress upon you that I have been doing this a very long time, actually about 25 years now. And I love what I do, and I hope and believe that I'm pretty good at what I do. Coincidentally, with the topic, I have been a national media advisor on legal and political issues. Here are some of my appearances: Fox News, Inside Edition, Larry King, may he rest in peace, I-24 International News, and many others. And again, I don't put this out to try to make myself sound any different than I am. I just really like to have people know that they can trust in the advice I'm giving and the experience that I've had, especially when it comes to something so significant as a divorce and the issues that usually accompany it, like custody and child support issues, your assets and your debts. This can be usually one of the most significant, challenging experiences in a person's life, and I want to make sure that you know you can trust in the advice that I'm giving you. So let's turn our attention into it. First topic we're going to talk about is non-disclosure agreements and protective orders. And before I go into that, this webinar is going to be a little different in format and possibly even a little shorter than most of mine because I'm targeting a different area than my normal broad approach to men's and fathers' rights and divorce. And here I'm talking more about sports and entertainment figures, media personalities, people with high profile divorce cases. But it doesn't really need to be that specific. Anybody that's a professional, for instance, doctor or a psychiatrist, an attorney, these issues will also arise in these types of divorces, which is why when I entered it's for even if you're a public figure, because it's not just your high profile cases that have these issues, but anybody that has a reputation to protect. It could be on a local level with your clients as a medical practitioner or a doctor, or it could be in the media if you're a sports and entertainment figure. So the first thing to look at is non-disclosure agreements and protective orders. Now, they are often common in divorce agreements, especially with a medical profession, or we're not going to touch a great deal because they are going to be very individual to your case and your issues. You know, for instance, if you're a doctor, HIPAA is going to be very important, but if you're a sports figure, it's not. But just understanding when one is either proposed to you or you're trying to get one, the purpose is to protect your privacy and intimate details from being disclosed or leaked to the press. So what's most important, in my opinion, when it comes to these types of agreements, because they're usually relatively standard, those of us that have practiced long enough have come across these agreements in many forms. And a lot of attorneys or practitioners will treat them as a matter of form, but it's very important that they be well tailored to your specific needs. So what I usually recommend if I'm representing the client who needs the protection is to put in specific terms for non-compliance, sanctions for non-compliance. Many people don't like that because it's an unknown and nobody wants to obligate their clients to something that they can't control in the future. But it's important to have at least the intent of sanctions mentioned in any agreement like this, because it will be more coercive to the other person signing it to abide by it. All right, so let's move on. Just give you a couple of little pieces of information to know when doing this, because as I said, they tend to be formed when they start, but then they tend to be very well tailored to individual cases. So a couple things you want to make sure is that it not only binds the parties and exposes them to sanctions, but that it covers any third parties that are going to be involved in this litigation or come into contact with the information from it. You can have court-ordered professionals, mental health experts, forensic accountants, business evaluations. You'll have stenographers for depositions. You'll have court clerks. You'll have office staff that this information will be passing. There's going to be people possibly that you're not even contemplating that could be working in the office, or some are intern. You need to make sure that the language is, on the one hand, broad enough that it covers third parties, but specific enough that it names the individuals who are considered bound by this agreement, so that the people who are receiving this information and charged with its care and protection know that they're exposing themselves to a breach if certain individuals come into contact and aren't aware of it. And these people also may need to sign the agreement. So when it comes to naming these people, like I said briefly, you want to make sure that there's teeth for the breach provisions. The hardest challenge in family court, for me at least, and my clients, is getting the court to put teeth and enforcement behind its orders. So for instance, any of you that have been through any kind of contentious litigation, high conflict divorce, knows that you'll get an order from the court, for instance, when it comes to exchange information. It will say information has to be provided in 30 days, but it never says what happens if it doesn't happen. 30 days comes and passes, and then you have to file yet another motion for sanctions for not complying with the 30 days. And then when you ask the court in either the first one or the next application for sanctions, more often than not, you won't get them. 2-3 times afterwards, then possibly, but not before. So if you're drafting an agreement that may later become subject to enforcement, putting in specific provisions in the event of its breach, teeth, as I like to call it, ensures that the court's bound by that and will have to impose those sanctions. This next topic is going to be very significant. Recording conversations it's got a lot of specific issues. It's got a lot of important issues because it comes up often, not just in high profile divorce cases, but very often in domestic violence cases, in custody cases, disputed custody cases, and many other issues. So let's look at some of the issues you will have around recording conversations. First, and most important, this advice, actually, I should have said this in the introduction, this advice is always limited to people in New Jersey. When I'm speaking about the law, even though I try to speak generally about the law and practically and avoid legal jargon or citations, I still am only licensed to practice in New Jersey, and I am only speaking about my experience in New Jersey. That's very important when it comes to recording conversations, because New Jersey is what's considered a one-party state, which means only one party of the conversation needs to know or agree to being recorded. And that would be the person recording it, probably you. Now, it may seem a little odd that you're the person recording and you have to consent, but really what the law is saying, even though they use the term one-party state, it means that only you, it really means that the other person doesn't have to consent to being recorded. I don't know why they phrase it this way. I'm sure there's something in the legislative intent or the history, but to understand it clearly, you don't need another person's consent to record their conversation if you're in New Jersey. Now, you have to be careful, because if you're recording a conversation in New Jersey of a person outside of New Jersey, their laws may be different. Now, I generally believe that if you're recording in New Jersey, somebody out of New Jersey, you're still entitled to record them because you are in New Jersey. But there's an underlying issue that I can't go into in this case because it's far too complicated. But there's something called conflicts of law, which means that every state has a conflicts of law that says, depending on the issue, which state's law applies. So while you may be in New Jersey doing something to somebody in Pennsylvania, if Pennsylvania's conflict of law states something different, then New Jersey law may not apply. Now, I know that may sound confusing and probably annoying how many times I have to say the word law, but it's a very intricate issue. Keep it in mind, be careful. But my advice is if you're recording a conversation and you're in New Jersey, you do not have to get the other person's consent. Now, as a caveat, many judges will frown upon a party recording conversations for various reasons. First, judges just often don't like it because they want everybody to be nice, play in the sandbox friendly, and settle your case and move on. And unfortunately, many judges aren't realistic to realize that some cases just aren't postured for that. It's not going to happen. Second, and more importantly, they know that you know you're recording and that the other party doesn't know he or she is being recorded. So you're on your best behavior and they're on their worst. You're also most likely recording the part of the conversation that's most favorable to you and least to them, as well as not presenting the entire conversation to the judge. So there's a lot of issues that come up. Despite all of that, my advice generally is still do it, because it's better to have proof that a judge may not like to hear than no proof at all. If you're recording a conversation, it's because you believe there's going to be a need for it, or you've been advised by somebody there may be a need for it. So best to have it and deal with the repercussions that may come from it. Now, when I talk about recording conversations, I am generally speaking about an audio recording or digital recording, but that doesn't mean that you shouldn't also consider recording things in writing, by emails, by notes, old-fashioned confirmation letter. And it doesn't necessarily have to be something that you sent to the other party, although that's certainly good. It can be just a journal that you keep. Could be a Google Calendar where you put down your notes, or your Outlook calendar. You can even email things to yourself. If you're making notes about something at the time that it's happening, it usually is admissible in court and can often be admissible against another party in court. Now, these are rules of evidence. I'm not going to go into that in this video, but it is good to have it. I also have on my YouTube page, which you can just search my name, Brad Micklin. I did a two-part series in 2020, I think, right in the beginning of the COVID-19 quarantine. Did a two-part series of how to use email tactically in either a divorce case or custody case. I'm not sure, but if you go on my page and you search email or email tactics, or it should show up. And I go into this a little more in detail about how to use various email carriers and online services to both store and save and retrieve information, because this is the most helpful. Recordings are hard to use in court because they're messy and cumbersome. You know, you may have a 5-minute recording, but you want to use a 30-second split of it. You also need to give your adversary copies and a copy to the court, so you have to make digital copies and provide it. It's cumbersome, especially if you're representing yourself. But even for lawyers, a lot of lawyers aren't technologically savvy when it comes to certain methods of court presentation. So writings are always more convenient, at least as I'm recording this, which, by the way, is November 18th, 2021. So again, I do have some other webinars I'd recommend that you see about recording conversations on my YouTube page. It may also be on my website, but I think there's more on my YouTube page. Next, the often kiss of death in divorce cases, especially of high profile media or sports and entertainment, is social media. First, stay off social media. There's very little good that comes from posting on social media about anything related to your divorce, your custody, your children, or your spouse. Now, the reason why it's here, I could just end it that easily, but if you are a high profile individual or professional, you may be using social media for your job. Most of the reason why I use social media is to network with friends and clients and to promote my business. So I understand it's not as easy just to say, well, stay away from it. You may not need to, or you may not be able to. So if you're going to be on social media, just some tips you want to use, almost common sense, but sometimes it needs to be said anyway. So, well, and before we go into what you do for a high profile case, so on the side, never post anything about your children. First, it exposes them to risks that others will be able to identify them and find them. And unfortunately, some children have been kidnapped because of social media postings. And a lot of people, professionals, will frown upon that for that reason. Judges, mental health experts, custody evaluators. So when it comes to children, it's pretty much safe to say keep them off social media, especially during your divorce or custody case, but even afterwards. So if you are going to be posting, don't post anything that you wouldn't want a judge to read. And I say that because I hope it gives you sort of a phrase to keep and understand how to write something. I could say don't be abusive. We could say don't use foul language, but that doesn't really capture what's important. I always say don't write anything you wouldn't want a judge to read because the judge may be actually reading it one day because social media doesn't disappear. I don't fully understand how it's preserved on the computer and sort of the back channels, but I know even if you try to delete social media, there is a record that is maintained. And if you do try to delete your social media posts while you're in litigation or in contemplation of litigation, that could be a contemptible offense because it's destruction of evidence. So it can be very messy. Social media is still relatively new in the context of being heavily involved in high conflict litigation. And the bounds of using it and not using it and abusing it are still being defined. So always use care when posting social media. And by the way, as a side note too, it's when I tell you, oh, don't post anything you won't want a judge to read. I also say this a lot when I talk to clients about leaving messages. And it doesn't really have to do with this, but I do want to go on a little side because it's important. If you're in divorce or high conflict litigation, it's very easy to lose your temper. It's a frustrating, complicated, costly process. And people will routinely leave nasty messages, abusive messages, hostile messages on a voicemail or a text message. They lose control. They just spit it out and it's there forever. Don't do it. It can and often lead to a restraining order. It can be used against you in a court. Not to sound like you're being registered for the Amendment rights, but always write, always leave messages, always use a tone as if a judge is going to hear it, read it, or see it. With everything, not just your social media. Exercise discretion. Not like I was saying with social media, because as I said, social media is a very new creature. But this I'm talking about you just when you're outside in public. And this may sound like odd advice, like what's the matter if I'm outside in public? But two reasons. First, if you're a high profile individual, there's people following you, there's people watching you, there's people trying to record you to get near you. If you're a professional, you may be bumping into clients, people may recognize you out in public. You don't want to do anything that could impact you negatively in the court's opinion, in your adversary's opinion. You don't want to disclose anything that you don't want other people to know about. And again, just like I said about social media, the world is adapting and technology is changing that now it's rare that you're going to be out somewhere and there's not a camera nearby somewhere recording what you're doing, recording what you're saying, recording who you're with, who you're not with, where you're going, what you're taking, what you're carrying. There's a lot of reasons to be careful when you're outside. Now, I'm not trying to make you paranoid that you got to look over your shoulders everywhere, but keeping in mind this is intended for sports entertainment figures, media personalities, high-profile cases. These are concerns that you need to be aware of, not just for your business and your personal persona, but in your divorce and your custody litigation as well. Now, the next topic is going to be more towards your specific sports and entertainment, media personality, high profile divorce. I'm sure it could, I guess, relate to public individuals. Now, we're talking about like agents, your public relations agent, your publicist, any media consultant you have. I guess professionals and anybody with high profile, even on a local level, may have assistants, staff members, somebody to work closely with, somebody you sort of like. We all have, well, not we all have, but many of us had like that one trusted colleague or employee that kind of handles our whole life. It may be your publicist, it may be your secretary, it could be your girlfriend or boyfriend. But have whomever this person is meet with your attorney. Actually, maybe a slide back. Have you meet with your attorney, because primarily the attorney is going to be interacting a great deal with this person or these individuals. You want to make sure that they know and understand one another. You want to make sure there's a rapport. And you're going to also need to make sure that your attorney understands and maybe has in writing authority, if you want him or her to have the authority to consult directly with this individual in place of you. There may be times where that's needed. That may be how you operate. That attorney is not going to, your attorney is not going to be able to discuss your case directly with anybody absent your specific written permission to do so. There's also, you want to make sure that both your attorney and the individuals that you employ understand the parameters of your case. They understand what they will and will not be handling, what they will and will not be involved in, and make sure that all of these players understand one another. Because you may have a trusted employee or a publicist that doesn't want any part of your divorce. They could possibly know your spouse. You may be unaware that they're so friendly with your spouse. Some just may be uncomfortable being put in the middle. You may not want them to know your private business or how much money you have in the bank or what your credit card debt is. So you have to think these things through. You have to discuss it with your attorney first, set the parameters, and then invite the other trusted individuals to meet with the attorney so that you're all working together with a clear understanding. Plan filming. And I don't mean for media personalities or news shots. I'm actually talking about if you're going to be filming either your interaction with the other person, like a recording, just a video recording, or possibly your children. But more often than not, where I encounter recording is with custody issues or adultery issues. I'm not going to go into the significance or insignificance of adultery. That's another very complicated topic beyond the scope of what we're trying to talk about here. I do have some other webinars on my YouTube page and my website about the grounds for divorce and the basic process. It's more appropriate for that. Here, most often I'm using it for determining whether or not people are either spending time with their children as they certify or claim to the court, and who else is with the children, who's watching them, who's coming into the house with them, who is the other parent dating. But this also can be used if you're trying to show what your time with your child is like, or what your conversations with your potential ex-spouse or the parent of your child. This is helpful because I'm sorry, I just lost my train of thought. The video is still going. This is helpful because in a lot of high conflict cases, there'll be allegations of domestic violence, not just those seeking a restraining order, but also those seeking to gain advantage in the divorce or custody matter. So it can be helpful for you to have videos of your interactions with the other person, again, without them knowing, if you're in New Jersey. So the short version is you want to start planning strategically how to do that. The first obvious thing is the location. You're not going to walk around with the camera in your hand those old camcorders that we used to, I don't know if they even still have those, but recording, obviously it's got to be tactical. When I use videos for types of surveillance, like for custody or for girlfriends, even for interactions, we try to have what's called a pole camera placed strategically near the location, usually it's facing the front door, for instance. And it can be programmed to run at either certain intervals or when there's certain motion, or it can be running just all day, and you have somebody sort through the videos to splice together the story of what was happening during what was recording. Because if you have 24 hours or 7 days of video, nobody's going to sit and watch that. So you can piece it down to show who was coming in and out over a period of time or what was occurring. So the next thing, you would also have to do timing. So you need to determine, and this is not something most lawyers will be helping you with. I work with private investigators who will normally do this because they should be licensed to do it. They also know if there's any permits or criminal action issues that need to be discussed. Sometimes they'll introduce themselves to the local police department so that they know where they're working out or where they're working out of. And it's also better that you not do it, because if you're the one filming it, you're also possibly exposing yourself to issues of stalking and harassment. Again, very important topic, too broad to go into in this one. And I know I sound like a broken record, but I do have videos on my website and my YouTube page that will cover those issues at length for you also. And prepare to defend, which is probably what this whole thing really should have been called. But in high-profile cases or high-conflict cases, certain things are more important than they might be in other cases. So, for instance, New Jersey is largely a no-fault state, which means, although we don't have a no-fault divorce, you can't just file a paper saying, I want to get divorced. You still have to choose one of the, I think it's 8 or 9 different reasons. One of them is irreconcilable differences, which is the closest thing that New Jersey has to a no-fault divorce and what most people commonly will file. But you still can file for fault. So that's usually a sign that there's either significance that they attach to alleging fault, or they're trying to raise the conflict level. Sometimes it's the attorneys trying to raise the conflict level. Sometimes they have a difficult spouse that believes it's important, so they start using things like extreme cruelty, adultery, sexual deviant behavior, drug addiction as the grounds for divorce, which you're permitted to do, but in the paperwork it's largely unnecessary. But be prepared for them. So there might be, for instance, like allegations of adultery, which will not usually significantly impact your divorce unless there's transfers of assets or dissipation of marital assets, other children, things like that. But more often than not, it's being used tactically. Many people on the receiving end of a fault-based divorce complaint worry that others will see that. Again, if you're high profile and people are trying to get your paperwork, some worry their employers are going to find out. That's generally never the case. Most people, I mean, although I think it is technically a public document, most people don't obtain them or try to obtain them, except, again, in high-profile cases. So you do want to be aware of the likelihood. Truth be told, I don't know how much weight people give to divorce filings, even in a high-profile case, because they know that generally just a form and doesn't mean it's true. It just means it's what somebody wrote. Although certifying and signing it's true, it doesn't necessarily mean that it is. That's a long story in a soapbox that I won't go into here. But nonetheless, people are very uncomfortable having their dirty laundry exposed in this way. They're afraid people will believe it, that it could impact their career or their employment. So be prepared for it. There's, like I said, like 8 or 9 different reasons. The most common ones are the ones I mentioned: extreme cruelty, adultery, sexual deviant behavior, involuntary institutionalism, and several others, 18-month separation. It's not serious, but of the fault-based ones, those are most of the ones to be prepared for. And just speak to your lawyer, make sure that you're ready for whatever you may get hit with. Now, alternate dispute resolutions. This I recommend in all cases. The older I get, the more I realize that the process just doesn't work. Those that are following my YouTube videos will note my current line of videos is hashtag family court sucks. And it's because that's what I think. I mean, with all due respect to the judges, I love the judges. It's where I chose to put my career, but it's very disheartening to see that the court just doesn't really do what it promises. It doesn't provide equity and fairness. And I know, and I've been telling people this for decades, that everybody's definition of fairness and justice is different. But I think in many cases there can be a universal definition of what would be fair and equitable in a certain circumstance, and the courts don't do that. I think they're more concerned, not more, but they are too concerned with the numbers of cases. Judges have a lot of pressure from the administrative office of the courts to move cases. So instead of trying to be fair and equitable, they're trying to get you to settle. And sometimes they use tactics that aren't fair and equitable. Sometimes they put pressure on people for no good reason because they want you to settle your case. Now, I'm not a judge. I don't plan on ever being a judge. Maybe there is some judicial wisdom behind that approach that I don't know about because I've been dealing with it for decades, and every judge that I know generally has this approach. So I could be missing something. But from where I sit and with my clients next to me, I just don't find that it's a positive approach to it. So alternate dispute resolution process. First is collaborative divorce. I'm generally not a fan of collaborative divorce. Collaborative divorce, not that you shouldn't do it. That's just my personal opinion. Collaborative divorces is a process where you hire lawyers, you hire whatever experts you agree that you think you're going to need, and you all agree that you're going to work confidentially for a common goal or for common goals, like fairly distributing the assets, coming up with a fair custody arrangement for the best interest of the children, whatever it may be. But the caveat is, if you don't come to a satisfactory resolution or agreement, everybody that you've engaged to help you in this, all the lawyers, all the professionals, all the experts, are barred from representing either party in the divorce that will follow. And that's problematic for a couple of reasons. First, if you're that reasonable that you believe you have common goals and you're committed to working together to reach them, there's no reason why you would need a confidential process. So by going into that, it almost begs the question of why is it necessary? I always say 4 reasonable people can settle divorce in 10 minutes. So it's more likely than not the people engaging in the collaborative process are keeping their options open, meaning they're going to engage all these people, you're going to spend all this money, and if they don't get what they want, then they're just going to wash their hands and make everybody start all over. And that can be a good pressure point because of the financial investment that people will make. You know, for instance, I've never done a collaborative divorce case myself. I've had my associates do it, but because the first one where I was engaged to do that, it was a custody case and they wanted a collaborative. I said, fine. Are you willing? And I said this to the mother's attorney. I was representing the father. I said to the mother's attorney, is your client willing to discuss the possibility of mine relocating to another state with the children? And she said no. She wasn't willing to give up custody of her children. It was going to be a disputed issue. I said, well, then what is the point of agreeing to a collaborative process if you're not going to be open to one issue? You can't tell me that you're working on common goals for the best interests of the children, but you're not willing to discuss a potential issue that's adverse to you. So I washed my hands of that. And generally, it's been my approach of collaborative cases. If you're interested in collaborative cases, I have a great associate that does our mediation and alternate dispute resolution processes because he's better suited for it. he's got a better disposition. I generally don't. I play it into my strengths, which is usually fighting in court. The next form of alternate dispute resolution is one of my favorites, and that is arbitration. I'm a very big fan of arbitration in most high conflict, high profile cases. First, because it keeps the process confidential. It's a very expedited, very inexpensive way to resolve any issue short of going to trial. Now, it doesn't mean that it's fast and cheap. It means it's faster and cheaper than going through the entire process. You also have control over the dates and the times, how much time you need to invest into the process, what dates you will, because the arbitrator and the parties can work the schedule, because you're usually just hiring an arbitrator. So, and I'm sorry, I guess I should have explained that in case those that don't know. Arbitration is where you hire an individual. It could be a panel of individuals, usually it's one. Retired family court judge, local practicing attorney, mental health expert, somebody, mediator, and you give them the authority to make a binding decision. So you put your information to them, you put your evidence to them, but they make a decision, you're bound by it. Now, there are ways to craft that you could possibly have appeal rights. New Jersey has a couple different statutes for arbitration, and the appeal issues are too complicated again for this. Maybe I'll do a webinar simply on that, as arbitration is becoming a much more popular mechanism. But so, you have this one person instead, handling just your case, or handling fewer cases than a judge. So when they pick a day for you to meet, they say, okay, we're coming Wednesday, 10 o'clock. You're going to meet Wednesday, 10 o'clock, start. If a judge tells you to come for trial Wednesday, 10 o'clock, you're going to get there and find out that he's got 25 cases, he or she's got 25 cases sitting out there, and they'll get to you when they get to you. And you end up spending all this time preparing, you're paying your lawyer to be there, you're missing your work. It can be ugly. So arbitration streamlines the process. Now, what's not good about it is, like I said, you're bound by it, and in many cases you can't appeal it. So if you get a bad decision, you're married to that bad decision. You can't appeal it, you can't reconsider it. There's nothing. So you need to make sure that the rights you're giving up are worth the benefits that you're getting from it. And it's only a question that either your attorney or people that have been through that process can help you understand. Next, the most common is mediation. I'm not a big fan of mediation. It goes back to what I said about collaborative law. If you're reasonable and accommodating, you don't need to be in mediation. More often than not, I see people taking the route of mediation as a way to get into a confidential proceeding, because mediation is also confidential. So if you mediate and you don't agree, you can't go to a judge and say, well, they offered me this, or I was going to give them that. It's confidential. So a lot of times people are trying to gain advantage because they have a stronger bargaining power over the other person. I don't mean financial, but sometimes they're more coercive. Sometimes they're more dominating. Maybe they know the buttons to push. So they want this confidential closed door forum to try to exert influence onto the other party in a way that nobody else will see. Also, a problem I have with mediation is, in my experience, most mediators don't really mediate the way that you're supposed to. A mediator is supposed to help two people come to an agreement. In my opinion, that means find out what person one wants and find out what person two wants, and try to help them come to something they both agree to. More often than not, mediators don't do that because that's very challenging, very time consuming in a high conflict, high profile matrimonial case, or any high conflict case, custody. So instead, they try to tell you, usually separately or confidentially, what the law is going to say and what you're entitled to. So if you ask for something that's unreasonable, instead of going to the other party and saying this is what they want, they'll tell you that's unreasonable. The court's never going to give that. You shouldn't take that position. Well, that's not mediation. If anything, that's arbitration. A mediator's job should just be to help you get what you want and help the other person get what she wants, or something that neither of you are too happy with, but it's a good compromise. So I generally don't favor mediation for that reason. So the next topic we're going to talk about pre and post nuptial agreements. So quickly, most people know what a prenuptial agreement is. It's something you sign, you agree to before you get married that says what's going to happen in the event you get divorced. A postnuptial agreement is that thing that you sign, but after you've been married. Some call it a mid-marriage agreement, sometimes called reconciliation agreement. But it's really about the timing. So if you do have either one, pre or post-nuptial agreement, first thing that's most important is make sure that you get it to your attorney. You'll be shocked at how many people say they have one, don't know where it is, or they go and get it and they find that they don't have the signed copy, or maybe the copy wasn't ever signed. You want to make sure that obviously you have it, that you have it signed, that your attorney has it. If you don't have one, get one next time. Because if you're in a divorce, you probably wish you had a prenup. And a couple of points to that. So I don't advocate a prenuptial agreement because it's, you keep everything and the other person gets nothing. Prenuptial agreements before marriage can be one of the best tools to help a marriage actually work. Because more often than not, people get married, they don't know what the other person earns. They don't know what kind of debt the other person has. They don't know how they use credit cards or how they save money or how they're going to make decisions together as you go forward. Prenuptial agreements help you do that. Postnuptial agreement helps you not get divorced. That problem with a postnuptial agreement, though, is currently the law doesn't favor them. Judges believe they are coercive, more coercive than a prenuptial agreement, meaning judges think it's sort of like, sign this or I'm leaving you. So unless it's exceptionally fair and the disclosures are great and there's a lot of time, there's a good chance your postnuptial agreement will not be upheld by a court, which I think is unfortunate because I think just the opposite. I think a postnuptial is less coercive than a prenup. I think a prenup is sign this or I'm walking out of this wedding. People, I would think, are more likely to jump ship before getting married than they are years after they are married. They have children together, they have assets together. So a postnuptial agreement, in my opinion, would be something that should be favored, but apparently judges in New Jersey don't yet agree with me. Time sharing custody agreements, usually the most difficult taxing trying issue in all divorce cases, or even if it's just a custody case, whether you're a sports and entertainment media figure, doctor, or unskilled labor. Custody time sharing is going to be very difficult. Now, the issues that you'll deal with, however, if you are sports and entertainment media or high profile, and professionals, again, I'm not trying to exclude them, is you don't always have the 9 to 5 that that many other people have. You may not have great control over your schedule. And even if you do, people may feel that you do because maybe you're a self-employed physician. But the demands of your office, the demands of your profession don't allow you to take that and still maintain the life that you have or the support obligation that you made. So you want to make sure that your divorce agreement has flexible provisions, especially when we're talking about children, but also very common when it comes to travel and the time that you're spending with your children. So if you're going to have a parenting time schedule that is flexible, you still want to have additional provisions for traveling with the children. Most important is going to be if you're traveling, not most important, the most common is going to be if you're traveling interstate. The law in New Jersey technically says once a divorce or custody case is filed, custody is at issue and no child can be removed from the state without permission of the other parent or a court order. Now that sounds noble, but it makes no sense if you live in New Jersey and you want to take your child to New York for the weekend, which may be a 20-minute ride at best, but you can drive 2 hours down to Camden County and not have it matter. But nonetheless, that's the way the law is written. So you want to have provisions that eliminate that issue. It doesn't have to be wide open. It doesn't have to say I can go to any state for any amount of time, but you can write things that I can go in the tri-state area for a weekend. I can go to my family's in Washington every Christmas. You can make it as broad or as narrow as you want. Just remember, it's usually going to cut both ways so that if you're asking for these provisions, the other party will ask for them also. They may be asking for similar, but in different areas that you may not want to be giving them, like other holidays or other trips. So it's something you need to consider, but I still do generally recommend that you keep it liberal as possible, subject to changing and modifications as your life changes and the children's lives change. International travel is always a very significant one because you, of course, if you can't leave the state, you certainly can't leave the country. But then there's also broader international concerns about, if you're not coming back to the States, if people are afraid of kidnapping. It's a real issue, one that you need to contemplate. So if you are a high profile or high conflict case, and you do expect you're going to be traveling, you want to make sure that you address these issues now while everybody's at the table, everybody's on the clock, all the issues are out, and you can determine whether there's going to be opposition to it or not. You don't want to wait until your divorce is over and you have a trip to China planned and your ex-spouse is not letting you go, and now you're finding yourself back in the court. Brutal. So take care of it first. College and child support. Another taxing issue for all cases. But again, when we're looking in the facets of sports and entertainment and media figures, you have different concerns. More often than not, the New Jersey child support guidelines don't apply. And what I mean by that is New Jersey has its set of guidelines that basically plugs in both parents' income, some figures about like healthcare, recurring medical, overnight schedules, and it calculates a number that gets paid, quite simply. The problem is that the guidelines only allow for a combined net income, combined meaning both parents' combined net income of, I think it's 187,000 as of now. So not to generalize, but quite often if you're a sports and entertainment figure or a professional, your income is going to be higher than that. So you're going to be beyond the child support guidelines. So what that would mean for you is that New Jersey is supposed to include a high income addition. And that means the judges are supposed to look at what are the needs of the child now and in the future, and how much do we add on top of the child support guidelines to accommodate those future needs. But now there's also a case that you see on my slide, Strahan versus Strahan, the three pony rule, which basically means no matter how much money you have, a child doesn't need three ponies. And what they're saying, the message is, there's only so much a child needs, even if you have an abundance of money and it's not a concern for you, that you don't have to be paying 50% of your income just because you make a lot of it, or you don't have to buy three ponies just because you can. Ultimately, the way the court will determine the high income addition is based on the child's needs. The court has a guideline. It's actually the same guidelines that they use to determine custody, the same factors. There's like 14 different factors to determine custody. Courts will look at those 14 factors also and determine inside of those needs what are the likely costs to assume that you will have now and in the future. So I would consult with your attorney. I would also consult with any professional. Speak to your accountant, to your publicist. Look at what issues will come in your future. You may be in the middle of a high conflict case, and you're going to need things like mental health experts. Reunification counseling is very common. So I put a site up here for Black versus Black. These individuals will also not only help you determine what support needs you have in the future, but you want to involve them in this discussion so that you know every issue is being taken care of. Of course, you can plan for college savings, 529 plans. What you want to do when you're deciding the savings component to college contribution, especially if it's many years beforehand, is you want to make sure that the agreement that you're making to set aside certain funds into a certain account, like a 529, that money will be designated as your contribution. I actually had a client came to me after he got divorced, and the agreement said the father's going to contribute, $100 a month, whatever it was, until 529 plan for X amount of years, and then use college. But it didn't designate whether that was going to be his contribution or it came off the top. And we spent a lot of time and money fighting over whether or not it should be his or it should be taken off the top. Ultimately, we were successful, but it's not something that you want to leave to that. So make sure it's designated. Even if you have a family member or another source that's going to be contributing into this fund or this account, make sure that that is designated as your share when it actually comes time to use it. Now, speaking about how to pay for college, and I say child support in college because there's child support even when you're in college, and there's college contribution. So they're actually separate, but they run parallel normally, meaning you'll have both to some extent. Again, there's modifications. Again, this is another topic that could take a whole webinar itself, which I think I'm actually certain I've done a couple webinars on that. But so picking schools now, there's something we have in New Jersey called the Rutgers Rule, which you may consider putting into any agreement, or even if you're going to a trial asking a judge to order. That basically saying that you're only going to be ordered or required to contribute to the cost of the education if your child had gone to Rutgers or to a local state school, even if the child goes somewhere else. Now, generally, depending on your income level and your educational level will determine whether or not a court would likely entertain that. Meaning if you're highly educated or highly successful or both, it's unlikely a court will do that because courts favor sending a child with the best foot forward. But that doesn't mean that they will and that you can't make that argument, but just keep that in mind. I put grad school contribution because a lot of people ask about that. Ironically, the lead case in New Jersey about college contribution, Newberg versus Rico, actually was a grad school case, and most people, even lawyers, don't recognize that. So it leaves the argument for grad school contribution, and there was actually even a trial court judge, whose name I won't mention, a good judge, was around a long time, one of my favorites, retired at this point, had, I probably wouldn't bother saying to keep his name because if you research, you might need to dig it up, but he ruled for a grad school contribution, but it was in a case of significant assets, and it was an aberration. But it is there. So generally speaking, at this time, New Jersey is not likely to order you to contribute to grad school under most circumstances, absent significant wealth and or significant levels of education of the parents. As far as your child support obligation, as I said, both run parallel. There will be an adjustment to child support, usually when a child goes to college, because there's parallel expenses, meaning if the child's, even if the child's living on campus, for instance, there's housing and room and board costs for college, but one of the parents is likely keeping some kind of space for the child to come back on vacations and summers. And by the way, if it's not, if the child's living all year round, then what we're talking about may not apply because you're going to be paying for housing there. You don't want to have a double dip. But normally, most commonly, there's a place to return to. So there is going to be some child support that goes to the person maintaining that home, but less than it was before. And there's always a lot of what I call extras when talking about both college preparation and college living. If you're living at home and commuting, obviously there's going to be a car. There's going to be car insurance. It's hard to find any child nowadays that doesn't have a cell phone. Extracurricular is somewhat important. It becomes less important, I think, as the child gets older and starts moving on to college age. But there still will be extracurricular. Often the education itself may bring extracurricular activities that are required. Sometimes they have certain study programs or internships they need to perform. So you want to build this in, test taking, build in whether or not it's going to be something that you contribute to. Next is the distribution of assets and debts. We do that in what's called equitable distribution. So first, painter versus painter, I'm not going to go in great depth. It was put in here just because it's something to go to research if you have a significant asset case and you want to have some guidance. Issues of dissipation of assets are also very common in equitable distribution. And I put that here because I think it's often raised but commonly misunderstood. People often argue that assets have been dissipated simply because they were spent or they were frivolous with it or they were spent in ways that they might not have agreed. But the definition for having dissipated a marital asset is very specific. Largely, it's about transferring it with the intent of keeping the other spouse from getting it in a divorce. Well, if you're spending money gambling, that doesn't mean that you did it with the intent of keeping it from your other spouse. You might just have gambled it away. If you spend it on a girlfriend, arguably, it still wasn't about keeping it away from your spouse. The intent was to spend it on somebody other than your spouse. But it's a shade of gray, especially when you come to those issues. But if you are high profile or you have high assets, understand what that law is. Speak to your attorney about it to get the ins and outs, because it is likely to be something alleged, because it's a very common way to seek greater than an equal distribution of your property. And important to note, we do call it equitable distribution for a reason like that. It's not just equal, it's not just cut in half. So be wary of equitable, or be wary of dissipation claims. Be wary that you may need to investigate to make sure that the other spouse didn't dissipate assets, even if you're the wage earner, the high earner. You may not be the one controlling its use, and you may be surprised to find that there has been dissipation. There are issues about exempt assets, like there's premarital assets, and people think, well, I owned my house beforehand, don't I get to keep it? It's not that simple. There are pre and post marital assets and active and passive, that the definitions affect all those classes. So it's important to understand what is and is not exempt property so that you can make sure to preserve it. In a lot of high profile cases, you're going to be dealing with complex assets like patents and trademarks, royalties now and in the future. Make sure that your attorney is well versed in these areas. I was going to say not many are. I can't say that to be the case, but not all of them are. And with the growth of the internet and internet marketing and internet publishing, there's a lot of new assets out there that not everybody fully understands. So you want to make sure that your attorney does and that you protect it. You also may have property that's out of state, out of the country, businesses, royalties, assets of any kind. You want to make sure that your attorney, not only that your attorney is aware of that, but you will also likely need to have an attorney in that jurisdiction or in that state or country, wherever that is, because most likely the laws are going to be drastically different. And there aren't, to my knowledge, many international divorce attorneys when it comes to assets. You'll find international custody, you'll find international kidnapping, but I don't think there are any international divorce attorneys from an asset standpoint. I'm not the first one to tell you that, and I don't know anybody who would. So I would always recommend you have somebody in that form that knows what your needs are going to be. All right, so let's move on into discussing a little bit about taxes. First, I am not a tax attorney. Most divorce attorneys are not tax attorneys. Tax attorneys are tax attorneys. So I always tell my clients, seek professional tax advice. I know it may sound simple. There's only one slide I'm giving you on this, and that's because if you're high net worth or high profile, you're likely to have significant tax issues, both to your divorce, to your separation of assets, to your property, both current and future. Make sure you have good tax planning. Estate planning, topic nobody ever likes to talk about because they think that you're talking about death. I don't think that you are. I've always believed estate planning is talking about life, especially in the case of a divorce, because when you get divorced, when you file for divorce, the law revokes any will that you had before then. Now, that's normally good because often your will would have left everything to your spouse that you might not want to have occur that way. But having it just automatically revoked doesn't help you entirely, because if you file for divorce and your will is revoked, but you die during your divorce, your spouse may still get the assets that you didn't want them. So the first thing you do, and the first thing that we do, is draft a new will. And even if you have complex, multifaceted, multinational assets, I still draft a very simple, very fast will, just to make sure that you have something in case, God forbid, something drastic happens the day that you leave your attorney's office. And that is morbid, and I apologize, but it can happen. You want to make sure that it's taken care of. After that, you want to have more sophisticated estate planning. You want to decide, do you need to discuss trust planning? Are there issues with your children and custody that may be issues in your future? Depending on the level of your notoriety, depending on the level of your assets, will determine whether or not you need trust planning. Make sure, again, that your attorney is well versed in these areas. If not, he or she would have probably a colleague that they work well with that can help you with those areas also. Talk a little bit about Peneta Lite and alimony payments. Just so everybody's clear, Peneta Lite is a term you'll hear. That means that's Latin for while the matter's pending. So Peneta Lite support is obviously while your matter is pending, what you start paying in your divorce up till its end. And then alimony is whatever you're ordered to pay or agree to pay after you get divorced, if anything. A couple of things that are important to understand for high profile cases, high asset cases. First is the momentum of marriage. So, and this is more often for the acquisition or improvement of business interests, professional degrees. The concept is that if you had an asset, let's say you're a physician and you are married the day that you graduate medical school, the day you're getting divorced 25 years later, you're still a doctor, you still have that same asset. But the practice that you would, if you had built from that day one, grew over time. And they're likely to be arguing that it was the momentum of the growth during your divorce, for instance, in my example, that led to the value at the end of your divorce. Conversely, if you were in practice for 10 years and then you got married, it might be argued that it was those first 10 years that created the momentum for the upward mobility in the value and assets during your marriage. Now, every practice, every profession, every entertainer or sports figure is going to have an entirely different map to have to measure this by. But it's important to know that it's there and speak to people who understand how you can track this issue and be prepared for it. Now, short-term marriages, there's not always alimony. Most people think there's never alimony, but there can be. Alimony is not limited to just one issue, like how long you're married or how much you make. But I say this because, and my slide says the opposite of what I'm saying, because more often than not, people think, or lawyers act as if there's a big discrepancy, there should be alimony. So if you're a high income earner and you're married 5 years, more often than not, lawyers are going to tell you you're paying alimony. And I think it's repulsive because it's not the case. Not the intention behind alimony. It's not consistent with the law of alimony, but it's what I hear time and time again. So I put it up here to bring it to your attention. I don't agree with it. That's why it's here. So that you know that you should not be agreeing to alimony. I mean, I'm putting this more simply. It doesn't apply generally, but my position is generally in a short-term marriage, even in high earnings, there shouldn't be alimony. And don't let people convince you otherwise. Now, alimony also is not to punish you for getting married, it's not as a reward for getting married, which is why I say short-term marriages shouldn't get one, because it is like a reward for being married. Alimony is intended to compensate a spouse who lost the ability to earn because of being married in some way, for some way or another, meaning they left their career, they raised a family, they moved, economic detriment. occurred. They lost something in a financial manner that they can't necessarily get back without some assistance, and that's what alimony's for. So that's why it doesn't just apply in a short-term marriage, in my opinion, ever, because there's usually not economic disadvantage in a short-term marriage. But it could be in high profile. So again, just be aware of the issue. There's no bright line rule for that. It's just kind of another soapbox of mine. Don't let them also say that because you earn so much that you pay alimony and the other person doesn't have to work or doesn't have the ability to work. There is a term of imputation of income that almost everybody who gets divorced in New Jersey would have some imputation of income, whether or not they're working, because they can work. The question is at what level. So you should always be figuring how will the court impute the income at what level. It will impact your alimony, it will impact your child support, and it will impact your college. It usually does not impact distribution of assets and debts, but who knows? Everybody's circumstance is different, so keep that in mind. A little bit more PL and alimony. In these kinds of cases, you're going to need often employability experts for the spouse. If there is that issue of imputation, I try to have both parties agree to what that imputation level would be, even though I'm saying here that you normally need an expert, and you will if you can't agree. But the experts are often very costly, and all they're going to do is look at the Department of Labor stats or run you through some tests and look at your resume and tell you what you could earn. It's not realistic because more often than not, those jobs aren't there anyway for you to get, and you're going to spend a great deal of money for the report and even more to have them come testify. Sometimes it's more economical to save that money, try to agree on a number, even if that number is a little bit less than the expert might say, because the savings you have in not needing the expert may outweigh the benefit of actually getting them. So I do that on cases where it makes sense, when we're not talking about hundreds and hundreds of thousands of dollars of imputed income, when it's something more nominal, because the difference in support, alimony and child support, is usually not significant when there's between 50 and 100,000 or between 100 and 200,000. It can be nominal changes, but again, it may not always be. So you need to understand these are options, not hardcore steps to take. Mandatory job searches. This is something that I ask for when I'm representing the husband that has a spouse who's not working and doesn't want to work. And I always say, well, who does? Most of us would do something else if we didn't have to work. So when I have a penitent lite order that says during the case my client would pay an X amount of dollars, I ask that the other spouse be required to search for X amount of jobs, show job efforts, and report every couple months to the court. Because normally your temporary support obligations are not modified during your case. So they get ordered in the very beginning with limited financial information, and they may last for a year or two in some cases. But if you get the court to order that they are supposed to be seeking jobs, if they're not, you can ask the court to modify or terminate their support because they're just milking it. And if they do it and get a job, then you can ask to modify it then because they're now working. And it's also better to get them working. If you're an alimony candidate, you certainly want them to be searching for jobs. I always try to get agreements for automatic reviews of support. Now, you won't get that at the penitent lite level from a judge because, again, they're not modified normally during a case. But if you're paying alimony, generally speaking, I usually suggest having a trigger built in for when it gets reviewed every couple of years. If a job is lost, if there's a percentage increase or decrease in support or in income, change in occupation, change in your industry, whatever it may be, if you think it's foreseeable, build it in. Just be careful that sometimes that's a double-edged sword too. So if, for instance, you build in that if your salary drops 25%, you get to review and modify support, it's likely they're going to back and say, fine. But if it goes up 25%, then I should be entitled to additional 25%, which wouldn't have otherwise happened if you didn't ask for that review. So it's a balancing act, but more often than not, it's helpful. Cohabitation. Very big issue in support cases, both at the liability level and after alimony. The law currently, having been amended, I think it was 2014, now has a really awkward provision about cohabitation. It says generally that if you're paying alimony and you prove cohabitation, the alimony can be terminated, modified or terminated. But if the cohabitation ends, the alimony can be reinstated, which to me is ludicrous because more often than not, I would think some people will try it. All right, let's go to court. If I lose, you move out and I'll go back and I'll get it again. So you go through this horrible, expensive process to terminate support. You get your support terminated and then they can come back and ask for it again. And while it sounds like a long time ago, 2014, I haven't seen many issues of that taken to the appellate division and returned because 6 years is not a long time in a lot of litigations. Divorces often take 1 or 2 years. Appeals take sometimes 1 or 2 years, and then it gets remanded. It can take 1 or 2 years. So they may be coming, but right now there haven't been many or any that I know of that have addressed that issue. I think it's a horrible issue. I think it's ludicrous, but it's the law right now. So beware of that. Along those lines, I usually recommend having a private investigator because it's a very challenging aspect to file for termination of support with cohabitation. You want to have as much proof as possible before you go in, because if you're successful, all you get is a trial to determine if it should be modified. So if you spend all this time and money to make a motion to modify support and you don't make a good application, it's denied, the other person now knows that you know they're cohabitating. They also probably know that you have a private investigator, which, by the way, goes back to my point about the video that we talked about earlier. So you want to make sure that it's as ironclad as possible before you go in, because you usually only get one shot. Watch for what I call double dipping. Alimony and equitable distribution are generally separate, but in a lot of cases, the assets that you're going to get, or the assets that you have in a high profile, high net worth case, are going to be income generating assets. And not every judge that I've come across properly separates both premarital income streams for assets, postmarital exempt property. So if you have assets pre or post marriage that generate income separate and apart from, let's call it, your day job, you want to make sure that it's properly being accounted for, both in how your alimony is calculated and how your assets are being distributed. Again, a very complex issue. I do believe I have some alimony webinars also that go in greater length, not only about the double dipping issue, but about cohabitation too, and the alimony reform. Again, I think it was in 2014. So that is it. I am recording this as a on demand. So normally I'd be taking questions now, but nobody's here. So that is my website. We can go on. It will have our phone number. It should have a number you can text for some kind of immediate contact. And my email will also be on there, which is Brad, B-R-A-D as in David, at Micklin Law Group, which is right on the screen here, MICKLINLAWGRUP.com. Thank you for tuning in. I hope the information was helpful. If I can help you, please contact me in any way that you need to, and I will do my best for you. Good luck and stay safe.